Gary Wall here, and this is Bridging the Week for December 22nd, 2014 to January 2nd, 2015, and today is January 5th, 2015. Good morning. Happy New Year and welcome back to work. I hope everyone had at least a few days to relax these past 2 weeks. New proposed rules and an amended proposed guidance regarding an old rule. 2014 ended with two affiliated exchanges proposing slightly different new rules on disruptive trading, which themselves were each slightly different from a new rule adopted earlier in 2014 by another exchange and under U.S. law, while one exchange amended proposed new frequently asked questions related to an existing rule on block trades just day after its initial proposal. Also, both futures and security regulators brought enforcement proceedings against firms related to violations of customer asset protection rules, while one legacy action involving MF Global was finally resolved. There was a lot that happened these past 2 weeks, while I did not produce a Bridging the Week, so let's play some catch-up. ICE Futures US and ICE Futures Canada proposed new rules expressly prohibiting disruptive trading practices and simultaneously issued proposed frequently asked questions. The new rules are scheduled to be effective January 14th. ICE's new rules are generally similar to a recently adopted CME Group rule, Rule 575, prohibiting disruptive trading practices, while its frequently asked questions are also similar to the CME Group frequently asked questions related to Rule 575 that went into effect on September 15, 2014. However, there are some differences. ICE Futures Canada's disruptive trading practice rules are somewhat different even from those of ICE Futures US. These differences are a bit too complicated to explain on this video, so I encourage you to read the article version of Bridging the Week at www.bridgingtheweek.com to learn of the subtle differences. Check it out. The CFTC fined Deutsche Bank Securities, a registered futures commission merchant, $3 million for violation of its requirements related to record keeping, investment of segregated customer funds, financial reporting, and supervision from October 1, 2009 through March 14, 2013. According to the CFTC, among other things, between June 18 and August 15, 2012, Deutsche Bank failed to comply with newly adopted CFTC regulations that restricted the amount of customer funds it could invest in money market mutual funds. However, the CFTC noted that at all times Deutsche Bank maintained sufficient funds in segregation for its customers. In addition, the CFTC cited Deutsche Bank for inaccurately reporting its financial condition in various required financial reports filed with it between June 2011 and August 2012. Finally, the CFTC also charged Deutsche Bank with failing to create and retain order tickets for various block trades it cleared for customers from October 1, 2009 through March 16, 2012. In settling the CFTC's complaint, Deutsche Bank did not admit or deny any of the Commission's findings or conclusions. Pershing LLC, a registered broker-dealer, was fined $3 million by the Financial Industry Regulatory Authority for not complying with Securities and Exchange Commission rules and its own rule related to the protection of customer assets. Specifically, the firm was charged with failing to maintain adequate funds segregated from its own operations to meet its reserve deposit requirement for the benefit of its customers from November 30, 2010 to August 5, 2011. The amount of Pershing's deficiency ranged from $4 million to $20 million. The firm was also charged with failing to maintain, as required, physical possession and control of all its customers' fully paid and excess margin securities in certain accounts from July 2010 to September 2011. FINRA also charged that these failures resulted from Pershing's failure to have an adequate supervisory system addressing its customer protection requirements. In addition, FINRA charged Pershing with financial reporting violations related to these matters. Pershing did not admit or deny any of FINRA's findings. Pershing is a wholly owned indirect subsidiary of the Bank of New York Mellon Corporation. On Christmas Eve, CME Group amended its proposed market regulation advisory notice, previously issued on December 17, 2014, containing frequently asked questions, that would have prohibited block trades between accounts with the same beneficial ownership under all circumstances. Such transactions would have constituted illegal wash trades under the CME Group's proposal. CME Group's amendment reinstates the language of its currently prevailing wash trade frequently asked questions, dated November 19, 2013, which states that block trades between accounts with the same beneficial owner and accounts with common beneficial ownership that is less than 100% are prohibited unless each account's decision to enter into the transaction is made by an independent decision maker, is the result of a legal and bona fide business purpose, and the block trade is executed at a quote-unquote fair and reasonable price. The revised frequently asked question now solely updates CME's prior wash trades frequently asked question to caution against engaging in wash trades to freshen position dates in physically delivered futures contracts, and to reflect changes in the CME Group self-match prevention functionality on CME Globex being rolled out by January 11th. And finally, the Commodity Futures Trading Commission settled its outstanding complaint against MF Global Holdings, the parent of MF Global's Inc., related to the collapse of MF Global during October 2011. In settling, MF Holdings agreed to pay restitution of US $1.212 billion to customers of MF Global, or such other amount as necessary to ensure that claims against MF Global are satisfied in full, although the CFTC already has acknowledged that a substantial portion of this amount previously has been satisfied. Holdings also agreed to pay a US $100 million penalty. However, this amount will not be satisfied until the claims of all customers and certain creditors are satisfied. In June 2013, the CFTC filed a complaint against MF Holdings, MF Global, John Corzine, and Edith O'Brien based on the firm's alleged unlawful use of customer funds. The complaint was amended in December 2013. The claims against Mr. Corzine, the former chief executive officer of both MF Holdings and MF Global, and Ms. O'Brien, the former assistant treasurer of MF Global, are still pending in the United States federal court in New York City. Well, that's it for this week's Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. In addition, on the website is a special article on recommendations by CFTC staff regarding the content of Chief Compliance Officer annual reports for futures commission merchants, swap dealers, and major swap participants, as well as information on some special deadlines for this year only for filing these reports. Check it out. Until next week, this is Gary DeWall. Again, welcome back, have a great week, and ciao!